Good morning, everybody. It's a pleasure to be here today with David Sonenshein. David Sonenshein is professor of law at Temple Law School, Philadelphia. David is here today for a short interview. We will be discussing the foundations of the criminal justice system in America. But before we move into the details, I would like to ask David to introduce himself and to tell us something about the purpose of his visit here in Parma.
I am a professor of law at Temple University in Philadelphia, as Stefano said, and I'm here as a Fulbright Fellow from the Fulbright Foundation to do a comparative law kind of a study with the law faculty at the University of Parma. And I'm enjoying it very much, and I'm learning a lot about Italian law.
Thank you, David. I think we should move on in this interview and start discussing the basic principles and the sources of law as far as the U.S. criminal justice system is concerned. You're a teacher of criminal evidence, civil evidence, criminal procedure, civil procedure at Temple Law School, so I think you're more than qualified to give us an overview of the American U.S. system and then to discuss the sources of law and the course of proceeding. Please.
Couple of things. First of all, in the United States, of course, the sources of law are both common law and code or statute. So common law as in England, some statutes or codes as in continental Europe. In civil law, the sources are primarily common law, case law. In the criminal side, most of our sources are statutory or code, not unlike the situation in Italy, for example. You have to remember a very important distinction between Italy and the United States. We have two completely separate systems. We have the state system, that is a different system in each of the 50 states for criminal law. And then we have a federal system. If a person has violated a federal statute or the federal code, that person is prosecuted by United States prosecutors as opposed to state, New York, Pennsylvania type prosecutors. Most of the crime that we talk about, violent crime, crime of that nature, is done in the state court system. So many of my comments will be directed to how the states in the United States handle this rather than the federal government.
I understand. So most crimes like murder, burglary would be dealt with in the state courts?
Correct. Sex crimes, burglary, extortion, robbery, all of those are handled in the state courts. That's exactly right.
And what are the crimes that are dealt with by the federal courts?
Federal courts involve violations of the federal code. They include antitrust, securities law violations, terrorism, for example, fraud crimes that are large scale, drugs that are imported, things of national scale as opposed to local scale.
I understand. Please tell us something about the individuals and the institutions involved in the criminal proceeding. I understand that there are two separate systems, state and federal, and therefore I expect to hear something about the prosecutor, the judges in the state and in the federal system. Are the judges and prosecutor acting both in the state and federal system, or they are acting separately because they're different individuals, different people?
The federal prosecutor, the federal judge, is completely separate from the state prosecutor and the state judge. They have no legal connection whatsoever. They will sometimes cooperate, federal prosecutor and state prosecutor, in making a prosecution, but in terms of actually handling a criminal case, there is no connection. And the state prosecutors, and many people will find this remarkable, I think, in Italy, are in fact elected in a popular party-run election. There are Democrats running for prosecutor and Republicans running for prosecutor. And in all of the states but one, it is done by election. The judges in the state system, once again, are elected in a popular election. They are not professional judges. They can be anyone. They can be legislators, they can be regular lawyers, politicians, anybody at all. They're elected for 10 or 12 years and then get reelected, which of course is very different from the professionally trained civil servant type judges that you would have in Italy, for example.
How about the federal judges?
Federal judges are appointed by the president as are the federal prosecutors. They are appointed by the president with the help of the attorney general, and they are political offices. There are about 95 United States attorneys' offices throughout the United States, and every one of those is named after an election by the president.
I understand. Does that mean that the U.S. attorney in each state will be arguing cases in court when a case of murder, a case of burglary take place?
U.S. attorney, him or herself, is really more an administrative position. But the U.S. attorney might have 85 or 100 assistant U.S. attorneys who actually go to court and argue the cases. But that's their job. They are a professional staff that does nothing but go to court and argue cases.
I understand. Please tell us something about the police system, because I understand that also police forces are different at the state level and the federal level, correct?
Right. At the state level, you have police who are quote-unquote state police employed by the state, for example, the state of Pennsylvania. You also have in each city a local municipal police force who are employed by the city. Those are the police that the state prosecutors deal with. At the federal level, the federal prosecutors deal with the FBI or the Drug Enforcement Administration or alcohol, tobacco, and firearms, who are the federal police.
Understood. Let us now discuss a little bit the course of proceeding, a typical course of proceeding at the state level in the United States. Normally the proceeding begins with an arrest.
That's correct.
I guess.
Yeah, in the United States, the police, rather than the prosecutor, ordinarily initiate the entire criminal process. The police investigate, sometimes with the prosecutor's cooperation, sometimes not. And the police make a determination that there has been a crime, and the police make an arrest, and very often the prosecutor is not involved until the arrest has been made. And then for the first time the police call the prosecutor to say, hey, we've got a guy, we arrested him for murder, what do we do now? So arrest is where it begins. Investigations are conducted ordinarily by the police, not the prosecutor. And once the investigation is completed and the police determine there's probable cause to arrest, they make an arrest, and at that point, the suspect is then arraigned, brought before a magistrate, read the charges, counsel appointed, certain situations as well. At that point, in most state systems and in the federal system, the prosecutor will seek an indictment from the grand jury. The grand jury is 23 citizens, no professionals, just 23 citizens, and the prosecutor must convince them by a small preponderance, not by a whole lot, but convince them that a crime's been committed and that this guy did it. At that point, he is formally charged, and we start the trial process. As you know, although at the end, ideally, there will be a trial in front of a jury, 12 lay people, no judges, sitting in the panel. In fact, about 95% of cases are resolved by a plea of guilty or some other agreement with the prosecutor. So very few people actually go to trial.
What is exactly a guilty plea and what is exactly plea bargaining?
Prosecutor has many, many cases to bring and cannot possibly bring cases against everybody who's committed a crime. So he has to make decisions, or she has to make decisions based on priorities. And often, because the prosecutor has some doubt as to whether the case can be proven to a jury, and the defendant has some doubt if he or she will be found not guilty, they both avoid the game, they avoid rolling the dice, and they make a deal. And the deal ordinarily involves a prosecutor accepting a plea of guilty, that is, the defendant saying, I'm guilty, sentence me to a lesser charge, a lesser sentence than was originally charged by the prosecutor. The exchange is, we get a guilty, we get a finding of guilt if I'm the prosecutor, the defendant gets less time in jail or some other kind of disposition which is more beneficial to him or her. I will tell you that one of the great uses in the U.S. for plea bargains is to get co-defendants to testify against other defendants. And so if you have a small drug dealer and a big drug dealer, You make a plea bargain with the small drug dealer. He agrees to testify against the big drug dealer, and thus the plea bargain works to get the big guy.
Understood. Provided that the guy does not submit a guilty plea, but provided that the guy will answer, "I'm innocent,"
Yes.
to the question of the judge, then the case proceeds to trial. The first big event is the jury empanelment, the choice of jurors. How does that take place?
Well, it's very different in the state courts versus the federal courts. In the state courts, most state courts, the lawyers handle the empanelment of the jury. That is, jurors are brought in. They're looking for 12 jurors, 12 impartial jurors, they hope. They bring in 50 potential jurors, and they ask them questions. The lawyers ask the jurors questions. Do you know the defendant? Have you ever been a victim of a crime? Do you know the judge? Do you know the lawyers? Et cetera, et cetera. Beyond that, they can get into the attitudes of the jurors as well. And, as I think you know, very wealthy defendants will hire psychiatrists, psychologists, sociologists to study the jurors and help advise them as to who the best jurors would be for them. And that can be, in some cases, a very big business. When the lawyers are satisfied that they have 12 jurors who are impartial, they can then start the trial. In the federal system, the judge questions the prospective jurors, not the lawyers. And so jury selection in the federal system is very short. Judge asks a few questions, put them in the box, as we say.
Once the trial's open, then collection of the evidence, hearing of witness is the main activity during trial. How does the examination of witness take place, and what kind of activities are we seeing in the courtroom during the collection of the evidence?
Remember that the preparation of the case, the collection in that sense, took place pre-trial by the prosecutor. Talked to the police, talked to witnesses, victims, etc. At trial, examinations are conducted entirely by the lawyers. The judge is merely an umpire. The judge is neutral and rules on the admissibility of evidence. And so at trial, the lawyers do all of the work. And the prosecutor goes first, puts on a direct examination of prosecution witnesses. They are then cross-examined by the defense lawyer, who tries to make them not credible. And then when the government is done with its witnesses, the defense gets to put on its witnesses, and they reverse. The defense does the direct, prosecutors do the cross. When they're done, there are arguments. The judge then instructs the jury as to the law. Then the judge goes away. And the jurors themselves will apply the law to the facts and decide guilt or innocence.
Provided that the jury decide that the defendant is guilty, then the phase of sentencing begins.
Correct.
This is something unknown to the Italian system. There is an entire new phase which is directed to the determination of the quantity, of the exact duration of the penalty, of the detention.
Correct.
How does that work in the state system, in the federal system?
In both systems, it's the same in this situation. The judge has a separate hearing after the trial is over and there's been a verdict of guilty. The judge hears from the defendant. He gets to call witnesses from the state. There's a probation service that does a study of the defendant. There are arguments made, and then only the judge determines the length of the sentence. If there will be a sentence, it could be a fine, it could be a suspended sentence. Only exception generally is in capital cases, where the death penalty might be involved. And in those cases, ordinarily, the jury decides the sentence. And that will be after, in a sense, a second trial. Witnesses are called, and it could be weeks of trial on the issue of death or no death.